I'm Susan Goodwin of the Rivertowns League of Women Voters, and on behalf of our president, Susan Maggiotto, and our board of directors, I'd like to welcome you all to our Hot Topics breakfast. The League of Women Voters is a nonpartisan grassroots organization that in our second century now has been protecting and expanding voting rights. We also educate voters on current issues, and we advocate for legislation that we support. Now, this morning, we have a table in the back of the room. I hope you visited. We have our newest voter guides available, and you realize that early voting begins in just 2 weeks. Also on the table are some biographies of our panelists and our moderator. Please visit our website, and this is www.lwv-rivertowns.org, and there will be information there about some future events we're holding, such as next week we'll be doing some candidate forums for state offices. Now, this morning, we'll be going to law school. We have a panel of legal scholars that will be just taking a deep dive into some of the recent Supreme Court cases in the headlines. And I want to stress that this is an informational session. It's not a rally of any kind, and we will not be doing pro and con. This is purely legal scholarship. And if you're unhappy with any of the Supreme Court rulings, or conversely, if you support it, then the place to express yourself is at the polls, not in this room. Thank you for that. Now, I'd like to acknowledge our co-sponsors, and they are the Westchester Black Women's Political Caucus, as well as the American Association of University Women. So thank you for that. And a big thank you to all the Rivertowns workers who have put in so many hours to make this morning a success. Now, I would like to turn the program over to, before I do that, I almost forgot, we want to acknowledge George Latimer, who came. Thank you, George. And also Paul Feiner, who is here. Thank you both for taking the trouble to come. Now I'd like to turn the program over to Mayo Bartlett, who, among other things, is a distinguished civil rights lawyer. More can be found about Mr. Bartlett on the back table, where we have some bio sketches. So, welcome, Mr. Moderator.
Thank you very much. Good morning, everyone.
Good morning. Good morning.
It's a pleasure to be invited to moderate this forum today. I look forward to learning quite a bit, and I want to thank the League of Women Voters as well as the co-sponsors for having the vision to invite us all here today to talk about some really important issues. This Hot Topic Breakfast is going to discuss some of the more recent Supreme Court decisions, and I'm sure that our panelists may also get into some things that may yet be to come. I'm going to give a brief introduction of each of our panelists. There's more information, I believe, in the back, but I will give you just a little bit of their information. And following each of their presentations, after they're all concluded, we will have a question and answer period. There'll be some index cards that will be passed around. If you wish, you can put your name on that card. If you prefer to have your question anonymously, we will respect that as well. But we do invite questions. And our first presenter is Professor Inga Caldwell. She's an adjunct professor at Elizabeth Howe School of Law at Pace University. And there she teaches natural resource law and water rights law. And the law school happens to currently be ranked #1 in the country for environmental law. So we are very happy to have her with us today, and she will, I'm quite certain, present some tremendous information that we might not otherwise be privy to. She also has previously served as an Associate Executive Director of the Environmental Law Programs at the law school. And Professor Caldwell is a member of the ABA, American Bar Association section on Environment, Energy, and Resources. And she chairs the Constitutional Law Committee. She's going to discuss West Virginia versus the EPA, which basically limited the power of the EPA to regulate power plant emissions. It's an extremely timely subject, and please welcome her at this time.
Thank you. Good morning. I'd like to just start off by thanking the League of Women Voters and the co-sponsors for inviting me here today to talk about the West Virginia versus EPA decision. And thank you for that introduction. So I'd like to just start off with a little bit of background of how we got to where we are. And one of the first key Supreme Court decisions was Massachusetts versus EPA, which was decided in 2007. And in that case, the Supreme Court held, excuse me, that the Environmental Protection Agency can regulate greenhouse gases such as carbon dioxide under the Clean Air Act as, quote, air pollutants. And in that case, that issue was EPA's regulation of mobile sources of greenhouse gases, and the Supreme Court held that, yes, the agency's interpretation that air pollutants included greenhouse gases was correct. So then fast forward to 2011, and the case American Electric Power versus Connecticut. And in that case, 8 states, in New York City and 3 land conservation groups sued 4 electric power companies and the Tennessee Valley Authority, alleging that the power companies and Tennessee Valley Authority were causing a public nuisance by sending carbon dioxide emissions into the air because those carbon dioxide emissions were contributing to global warming. In a unanimous opinion by Justice Ginsburg, the Supreme Court held that the Clean Air Act displaced any right to a federal common law nuisance action. So in other words, it had to be under the Clean Air Act. The Clean Air Act gave the EPA the authority to regulate greenhouse gases, so there was no common law right for the states and New York City and these public groups to sue the electric power companies. And in that opinion, Justice Ginsburg discusses how important of a role the Environmental Protection Agency is as an expert, that this is a very complicated area, and it's important that we defer to the expertise of the agency. So that was 2011. 3 years later, in the Utility Air Regulatory Group versus EPA case, the Supreme Court held that, well, yes, we did say back in 2007 in Massachusetts versus EPA that air pollutant under the Clean Air Act includes greenhouse gases. That's sort of the general definition, but then you have to look at the specific statutory context. There's air pollutants are referred to under different areas of the statute, and so while air pollutant in some areas of the Clean Air Act includes greenhouse gases, in other areas of the Clean Air Act, it doesn't include greenhouse gases. And so that brings us to the West Virginia versus EPA case, which was, the court issued the opinion on June 30th of this year. It was a 6-3 decision. The majority was Justice Roberts, Justice Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And the dissent, authored by Justice Kagan and joined by Justice Breyer and Sotomayor. So, going back in time again, so the history leading up to this decision. In 2016, under the Obama administration, the Environmental Protection Agency promulgated the Clean Power Plan. And this was under the authority of Section 111 of the Clean Air Act, which is a section on new source performance standards. And so under this section of the Clean Air Act, the 111A, if EPA sets new source performance standards for a pollutant, then in 111D, EPA must then address emissions of that same pollutant for existing sources. So that's how we get to existing power plants, and that was the authority that they were citing here. And in the Clean Power Plan, EPA determined that the best system of emission reductions, that's the standard here, best system of emission reduction for carbon dioxide from these existing power plants was 3 steps. The first step was for the existing power plants to use heat rate improvements at coal-fired power plants. So in other words, upgrade the technology at those power plants. The second step was a shift in generation from existing coal-fired power to natural gas, because natural gas emits less carbon dioxide, and so there's an energy system shift that was part of the Clean Power Plan. And then the third step was a further energy system shift away from coal and natural gas power towards renewable energy, including solar and wind power. Immediately upon promulgation of this regulation, there was lawsuits filed trying to stay the implementation, so stop implementation of the Clean Power Plan, and the US Supreme Court actually granted that stay. Then we have a change of the administration. So nothing's been implemented. In 2019, the Environmental Protection Agency under the Trump administration found that EPA had previously exceeded its statutory authority under the Clean Air Act, and so President Trump's EPA repealed the Clean Power Plan, and then they issued a separate plan, which was known as the Affordable Clean Energy Rule. And that really focused on that first step that I mentioned, which was the technology improvements at the existing coal-fired power plants. A number of states and private parties sued to challenge the repeal of the Clean Power Plan. And the lawsuit was filed in the DC Circuit, the Federal Circuit, and the DC Circuit Court vacated the EPA's repeal of the Clean Power Plan and sent it back to the agency to reconsider. Then, fast forward, here we are under President Biden's administration, and EPA said, okay, well, we're rethinking the whole Clean Power Plan rule under the Clean Air Act, Section 111D, and so they moved in the DC Circuit to partially stay this mandate for them to look at the Clean Power Plan again, because the argument that they made is that, well, under the Clean Power Plan, our goal was to limit the amount of power in the country, in the grid, that's coming from coal-fired power plants. In the interim, since they promulgated the rule in 2016, actually the market forces have driven that change. So it actually met the goal that was set out in the Clean Power Plan of this shift towards more natural gas power plants and renewable energy. And so EPA said to the court, we're going back and looking at what else we can do now. The Clean Power Plan itself is moot at this point. Despite that, the Supreme Court decided to grant cert in this case and hear this case, even though EPA is and the current administration argued that this case is moot, and the court held that the case is not moot, and that the EPA did not have the authority under the Clean Air Act to regulate the whole power system in the way that they did. And in coming to this conclusion, the court focused on what it calls the major questions doctrine. And so Justice Roberts states that precedent teaches us that there are extraordinary cases in which the history and breadth of the authority of the agency has asserted, and the economic and political significance of that assertion provide reason to hesitate before concluding that Congress meant to confer such authority. And he goes on to state that this is a major questions case. EPA claimed to discover an unheralded power representing a transformative expansion of its regulatory authority in vague language of a long extant but rarely used statute designed as a gap filler. In the dissent, Justice Kagan says, this isn't an extraordinary action. This court has said before that EPA clearly has the authority to regulate greenhouse gases under the Clean Air Act. And this court has also focused on the agency's expertise to do that, and that we should be deferring to the agency here. And I know I have sort of limited time, but I just want to briefly mention the key case on deference to an agency, which is the Chevron versus Natural Resource Defense Council case. That was a decision from 1984. And in that case, the court held that if the intent of Congress is clear, then that's the end of the matter. So you just look at the text of the statute itself and you don't have to defer to the agency. But if Congress's intent is not clear, then judges are to defer to the agency's interpretation of the statute, provided that that interpretation is reasonable. There has been a pendulum swing away from deference to the agency, and I think by now inserting the major questions doctrine as the lens with which to look at agency authority here, it's sort of, the court did an end run around Chevron deference, and it will be interesting to see what happens with other current agency regulation of greenhouse gases. So in particular, thinking of the Security and Exchange Commission's recent rule on greenhouse gas disclosure. And I could see potential challenges to that under the major questions doctrine. I will say that Congress has since made it clear that greenhouse gases are pollutants in the Inflation Reduction Act, and has evinced a an intent to try to reduce greenhouse gases and through funding mechanisms. And that was a major portion of the Inflation Reduction Act that was just passed in August. So I think I'm going to stop there, and I look forward to your questions at the end of the program. Thank you.
Thank you very much, Professor Caldwell. Our next presenter is Rebecca Angel, and Ms. Angel is a third-year law student at the Elizabeth Howe School of Law at Pace University, and she'll be taking the bar in July of next year. We wish you the best of luck. She's been on the Dean's List for 3 semesters. She's a recipient of a Merit Scholarship and the Pace Law Opportunities Grant. And during the summer, last summer 2022, she volunteered at the Pace Women's Justice Center in the Family Law and Elder Unit, conducting legal research to help the unit's clients and assisting attorneys in the courtroom. She's going to discuss Dobbs versus Jackson, and that is the most recent Supreme Court ruling that overturned Roe v. Wade. So with that, I'm very happy to introduce you to Rebecca Angel.
Thank you very much for that introduction, and I'm honored to be here today. I'll be talking a little bit about the context in which the case was overturned. So to do that, I'm going to talk briefly about the cases that came before the Dobbs case and kind of their importance. And then I'll talk about Dobbs and then kind of the implications, what's been happening after. So to get started, it's important to understand this whole debate about due process and substantive due process. So basically, there are certain rights that are written in the Constitution that many of us know, right? The First Amendment, free speech; the Second Amendment, right to bear arms; freedom from unreasonable search and seizures. So these are within the first 10 amendments of the Bill of Rights. But there's been a debate about certain rights that aren't written in the Constitution. So the right to marry, the right to have birth control, and abortion has been in that kind of realm of this isn't written in the Constitution, but it's an implied right. So basically the cases leading up to Roe and then Dobbs. The first, 1965, we have a case called Griswold v. Connecticut. So there was a Connecticut law from the 1800s that banned married couples from using contraceptives. So the case, the Supreme Court held that a state can't prevent married couples from using contraception because that's a violation of the fundamental right to privacy in an intimate relationship. And this implied right to privacy, again, came from kind of the Bill of Rights. They call it the penumbras. So, again, the First Amendment, freedom of speech, the quartering of soldiers, which we don't see much. But it's a freedom of basically this privacy is what the court said. So 7 years later, we have a case called Eisenstadt v. Bard. And this was very similar to Griswold, but it banned unmarried couples from using contraceptive. So the Supreme Court basically said that if married couples can use it, then unmarried couples can use it as well. And you know, there's kind of this realm of privacy and private matters in the home. So they had an interesting quote, because when they actually issued this opinion in 1972, they had already heard the oral arguments for Roe v. Wade. So the quote here is, "If the right to privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child." So we get this kind of framework, you know, and this leads into Roe v. Wade the next year, the following year, 1973. The law here was that Texas banned abortion except to save the life of a mother. So kind of as an outgrowth of those other cases I just discussed, They said that the constitutional right to privacy protects a woman's right to choose to have an abortion. So this law in Texas violated this due process clause of the 14th Amendment. And they said the guarantee of personal liberty is broad enough to include a woman's right to choose to terminate her pregnancy. So with this, they came up with this trimester test. In the first trimester, which is like 0 to 13 weeks, more or less, there can be no restrictions, they said. The decision is between the mother and a doctor, and the state can't interfere. For the second trimester, that's 14 to 26 weeks roughly, and they said there can be maternal health restrictions. So a state can regulate in ways reasonably related to maternal health. And then for the third trimester, which is 27 to 40 weeks, post-viability, the state can prohibit abortion except to save the life of a mother. So they had this trimester test. This was criticized because with changing science, when viability is could change. And viability means when a fetus could survive outside of the womb. So then we get Planned Parenthood v. Casey. This is in 1992, so about 20 years later, and it partly overrules Roe because it said that this trimester test is, can change with science essentially, but they reaffirmed the core holding that a state can't prohibit abortion before viability. So before viability, that means around 23 to 24 weeks of pregnancy. And so this was 4 weeks more or less earlier than what Roe had held. And they also came up with this undue burden test, and there were a lot of cases that kind of arose under that, but that's not the test anymore because we have Dobbs v. Jackson Women's Health Organization. And the issue in this case, is the most recent Supreme Court case, was a 15-week abortion ban. So this is the very beginning of the second trimester. And the Casey court that I just talked about said there can't be any restrictions before viability, which again is like 23 to 24 weeks. So we're looking at 8 weeks earlier. And the core holding of Dobbs was that there is no right to abortion, so it overturns both Casey and Roe v. Wade. So the Supreme Court majority, which was a 6-3 decision, had this kind of originalist approach, right? This original interpretation of history and tradition. So they kind of started the analysis saying, okay, there's no express mention of abortion in the Constitution, which I mentioned earlier, right? There are some implied rights, but this wasn't written anywhere. This came out of this idea of a right to privacy, but that didn't quite cut it for the court. So there's no express mention. So basically because of that, there needs to be proof that's implicit in the, wording of the Constitution. So they said there's no equal protection because a state's regulation of abortion is not a sex-based classification, so there's no heightened scrutiny. So sometimes there's a heightened scrutiny if there is determination between the sexes, but they said there's no equal protection here. So it basically just gets the same regulation as other healthcare regulations. And then they talk about this fundamental right test, that a fundamental right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. So there's a little bit of a criticism here because it's implying that there's this other case, the gay marriage case, Obergefell, and they said about history and tradition, guide and discipline the inquiry, but do not set its outer limits. So we're seeing that was in 2015, a slight different approach here. So they said that abortion has no deep roots because it was criminalized at common law. So they're not looking at the practice of abortion that's been happening for centuries, but just the criminalization of it. And so they said because there was criminal punishment from the earliest days, of the common law until 1973, when Roe was decided, that there's no right. So the criticism, if you look at other rights, like I said, like same-sex marriage or interracial marriage, they were also criminalized when the decision was made. And so it's an interesting question whether you look at the criminalization or the practice. So that'll be something to look at moving forward. But it seems like this court's very focused on the criminalization, if it's not written in the Constitution. So they also said that the supporters of Roe and Casey didn't push the argument that the right to abortion itself has deep roots in our country. Basically, they didn't push the argument that since Roe, that has created deep roots in our country. So then they talk a little bit about precedent and stare decisis. So basically, Casey, the Planned Parenthood v. Casey, had broader rights of autonomy, and they talked about a little of the cases I just mentioned, interracial marriage, things like contraception, the right to make medical decisions, right to upbring your children, that sort of stuff. So they said what distinguishes the abortion right compared to those cases is that abortion destroys what those decisions call potential life. Right, and what the law here has called unborn human being. He says that these cases don't really undermine this decision, and they don't support it in any way. They're an opposite, essentially. So then we have this idea of stare decisis. Usually that means like the decision will stand once it's decided, unless it's so wrongly decided. But they said that when you're deciding if a case should be overturned, you kind of look to some different factors, the nature of the error. They said that Roe is egregiously wrong and deeply damaging is what they said. The quality of their reasoning, they said Roe didn't ground his decision in text, history, or precedent. And then they look at the workability. And they said that this like undue burden test from Casey wasn't a workable standard, essentially. And it was hard to know when something was due or undue. So they said this was kind of an ambiguous test that was hard for courts to apply. And then the last thing I'll mention from that is that they looked at the absence of concrete reliance. They said that there was no reliance interest in this case. They said women are not without electoral or political power. The decision returns the issue of abortion to legislative bodies, and it urges people to influence public opinion, lobby legislators, and vote/run for office. But I'll talk about the dissent's kind of response to that in a minute. But they talk about the role of public opinion, because there's a lot of criticism that they'll be viewed as a political body. People will lose trust in the court by overturning a case that was on the books for nearly 50 years. So what they say to this is it's important for the public to perceive that our decisions are based on principle, but we cannot exceed the scope of our authority under the Constitution, and we cannot allow our decisions to be affected by any extraneous influences, such as concern about the public's reaction to our work. And they said even if they could know what the reaction would be, it still wouldn't change the way they decided the decision, which is a little ironic because the opinion leaked. So they did kind of have a little preview of how people would respond. So to kind of end that, they said that basically because there's no fundamental right here, the standard for reviewing future abortion cases that might come to the court is just rational basis review, which means that they'll most likely pass, because that's a low standard. And then we have some important concurring and a dissenting opinion. So Justice Thomas, he doesn't believe in this idea of substantive due process. He thinks the only process that exists is procedural due process. So like the right to hearing, trial, that sort of thing. He doesn't think any of these cases really that were held on these grounds should be standing. So he said he thinks we should overturn many of those cases, like gay marriage, about contraceptives, the ones I talked about earlier, and the right to engage in private sex. So he thinks none of those should be protected by the Supreme Court. And then we get a concurring opinion from Justice Kavanaugh. He says that other cases aren't threatened involving contraception or marriage. And he mentions briefly that this decision doesn't allow states to bar residents from traveling to other states, because the court has also said there's a right to interstate travel, even though that's also not actually written in the Constitution, it's been implied. And then we get a concurring opinion from Justice Roberts, the Chief Justice, and he would have upheld the 15-week ban, but he said we didn't need to go further and completely gut Roe, because, you know, he's kind of been chipping away between these cases, but he says we didn't have to go kind of that far. He talks about judicial restraint. So then we get an important dissenting opinion from Justice Breyer, who is now stepping down from the bench. So they had some powerful quotes here, and I'll just read a few of them. Said, yesterday, the Constitution guaranteed that a woman confronted with an unplanned pregnancy could make their own decisions about whether to bear a child with all the life-transforming consequences that involves. Today, this court holds a state can always force a woman to give birth, prohibiting even the earliest abortions. They talk about an empty promise for liberty and equality. The Constitution will provide no shield, despite its guarantees of liberty and equality for all. And they say that the majority's reasoning is hypocrisy. They say the majority is eager to tell us today that nothing it does casts doubt on precedents and do not concern abortion. But how could that be? The lone rationale for what the majority does today is that the right to elect an abortion is not deeply rooted in history. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is either one or the other. They also criticize this original intent. The majority believes we in the 21st century must read the 14th Amendment just as its ratifiers did. The ratifiers didn't consider women as full members of the community embraced by the phrase, "we the people." Because laws in 1868 deprived women of any control over their bodies, the majority approves states doing so today. They talk a little bit about, actually a lot of it, about the impact this decision will have, specifically in Mississippi where this ban was taking place. So they said 62% of pregnancies in Mississippi are unplanned. Yet no insurance requirement covering contraceptions exists. Educators are also banned from demonstrating proper contraceptive use, and Mississippi allows for pregnancy discrimination and doesn't require paid parental leave. They said that it is approximately 75 times more dangerous for a woman in Mississippi to carry a pregnancy to term than to have an abortion. And states with the most restrictive abortion policies also continue to invest the least in women's and children's health. So these are all things in the state that would happen. But they also talk a little bit about the impact in the United States, and more importantly, impact on poor people living in these southern states. So something that Justice Ginsburg often said is that women with money will be able to travel to obtain an abortion, but poor women will suffer the most because they will have to travel further. They may not be able to take time off from work, etc. So women who live below the poverty line experience unintended pregnancies at rates 5 times higher than higher income women do. And half the women who seek to abortion care live below the poverty line. So they're talking a lot about the impact, which the majority opinion did not. And one other quote they have on impact: "Closing our eyes to the suffering today's decision will impose will not make that suffering disappear." They also talk about girls having fewer rights than their grandparents. After today, young women will come of age with fewer rights than their mothers and grandmothers had. And they talk about power over reason. Power, not reason, is the new currency of the court's decision making. So they have this concluding sentence that with sorrow for this court, but more for the many millions of American voters and women who have today lost a fundamental constitutional protection, we dissent. So I'll just briefly talk about the aftermath. Basically, this means that states can either ban abortion or have protections for abortion, and there's a real split. So there's a convenient map on New York Times. It's an interactive abortion laws map, and you can easily go on there to see what the different regulations in each state. But roughly, there's expanded access in 9 states, including New York, which is going to allow more protection than some other states. And then we also have protected access, which means that the right is protected by state law, but there are limitations on access to care. And then there's states where abortion is not protected in roughly half the states, or a little more, maybe 30. So it's not protected in 3 states. It's hostile in 15 states, which means that they want to prohibit abortion entirely. And then illegal in 12 states, which also wants to ban and also have criminal penalties for people who do receive one. There are various abortion bans. There are pre-Roe bans, basically bans that were on the books but not enforceable because Roe said that they were illegal. There are pre-viability bans, basically prohibiting abortion pre-viability, so before a fetus could survive outside the womb. And then there are also bans that copy the Texas law, which was like a vigilante law, like suing other people, but not the state official. So there are different states that are trying to copy that. There are also various restrictions, like targeted regulation of abortion providers, consent laws, needing consent from a parent if it's an underage girl, and then there's also something called the Hyde Amendment. So a few years after Roe was decided, there was a representative who introduced a budget rider, and it basically prohibits federal funding for abortion. So many poor women have not, even with Roe in place, been able to receive abortions. So what the impact we're kind of seeing here is that there's like abortion deserts, where it's illegal to access care, primarily in the South, so people would have to travel pretty far to get one. But there are also statutory protections. We're seeing that some states are saying that they, through statutes, protect abortion, and there are also state constitutional protections. Written in each state has their own constitution, and they can protect the right to abortion. So there's also kind of some implications here. We have medication abortion. There's an increased demand for medication abortion, which is taking a pill instead of having the procedure done. And it's FDA approved and legal in many states to receive by mail. And there's also contraceptive pills, which usually you need it through a prescription, but the FDA has made an application for a birth control pill that wouldn't require a prescription. So that would be interesting. We'll kind of see what happens with that. And there are a couple tests on abortion, which I'll just briefly talk about. Lindsey Graham introduced a 15-week ban on abortions. But this contradicted kind of the idea that each state can make its own decision, because if it was a 15-week national ban, then states couldn't allow abortion earlier. So we'll see, the success of that. And more recently, I think just a few days ago, the Supreme Court declined without comment to take up a fetal personhood case, which would basically determine whether fetuses should have constitutional rights subject to due process, and it was brought by a Catholic group, but they declined to take on that case. So my end message here is to vote and get involved, and not to take anything, for granted, to keep advocating for what you believe in. So thank you.
Thank you very much, Ms. Angel. Our final presenter is Professor Alexander Greenawalt, and he is a Stevens Family Faculty Scholar at the Elizabeth Howe School of Law at Pace University. He's a graduate from Columbia Law School, and he's clerked for the Honorable Stephen F. Williams, the United States Court of Appeals for the District of Columbia. He joined the law school faculty at the Elizabeth Howe School of Law, at the time Pace Law School, if I'm not mistaken, in 2006. And he has taught courses in constitutional law, administrative law, and criminal law. And he will discuss the New York Rifle and Pistol versus Bruin, which overturned the New York's concealed carry law. Before that, he was also at one of the preeminent law firms in the United States, Debevoise. He has served also as a visiting professor at Columbia Law School and at St. John's. For all of our panelists, there's much more that I could say, but in the interest of time, I don't, but please feel free to look them up, and you'll see that we are very fortunate to have them. Professor, please, thank you.
So I'm really glad to be here, and I want to thank the other panelists as well. It was missing from my introduction and Rebecca's introduction. Rebecca was a student of mine in constitutional law. We're musicians. We play in a student faculty band together, the Recess Appointments. She's a professional singer, and it's incredible. So I just wanted to mention that. I wanted to thank the organizers as well. I'm really glad to be here. I grew up in New York City, but my father grew up in Greenburgh. He grew up in Hartsdale. I don't get the whole. He grew up in Hartsdale, went to Edgemont, which used to end in 10th grade, and then fed into Scarsdale High. And I used to come up here all the time. Before I would do the drive to Pace for my commute, I would drive to see my grandparents. And my grandmother, Martha Greenawalt, was very involved with the League of Women Voters, was the president of the Greenburgh League of Women Voters, Westchester, New York State, for many, many years. And I would always see a lot of material from League of Women Voters when I go to her house. And so when I got this invitation, I was thinking, of course, I was really glad to be able to come. All right, so I'm going to talk about the Bruin case. So this is Second Amendment gun rights. And so what we have here is a New York law dating to 1905 that prevents most ordinary citizens from carrying a concealed handgun, generally. There's a proper cause requirement, which meant that I couldn't just go in and say, I'm interested in my self-defense and I want a handgun. For that purpose, I would have to show more than that. And so what happens, and this is, I'm just very basic summary of this law. Supreme Court struck that down in June. Okay, so just to compare this to the other two issues we talked about, and those are obviously both incredibly important cases. The takeaway from those two was we need to vote because the obstacles that that we have to greenhouse regulation, to abortion access, are fixable through democracy, right? As difficult as it might be, those are things that the way the court left it, those are things that Congress can address, voters can address. This is a little different. That this is the court saying, New York, we're not going to it doesn't matter what you vote. It doesn't matter that New Yorkers chose this law. We're telling you that it violates a constitutional right. So it's the right to bear arms. So there it is, Second Amendment, well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, there's been so much debate about this amendment, and this whole question of the Second Amendment is a test case for originalism, which we've been hearing about. So originalism, there have been change. Another theme today is there have been some changes on the Supreme Court, and these changes have been pushing more in the direction. We now have a majority of justices on the Supreme Court saying that they are originalists. So the current version of originalism says we need to give effect to the original public meaning of the Constitution, how the public would have received the Constitution at the time, and that meaning does not change with time. And the idea, what they say is, this prevents us from legislating from the bench, because there's a right answer to every single constitutional law question. It's not about what I want or you want, it's just about following the correct meaning. So we got a lot of focus on history, let's look up what did this word mean, like bear arms. Let's look up a dictionary, from 1791 when the Bill of Rights went in, etc. But there's some problems here, some challenges that people raise. First of all, it's not at all clear that the Constitution itself, that the framers of the Constitution were themselves originalists. There's all this open-ended language in the Constitution. Liberty, no cruel and unusual punishment. They didn't put in a list of, like when your parents tell you, when you grow up, don't be cruel to other people, but that only means like the list of things that I had in mind. That's a value that we have, and there's a lot of values in the Constitution. That's the way it was written. It was written in a very open-ended way. So one argument is the framers, what they thought was that future generations would interpret this language. And this is the general outline for our society. It's not a straitjacket. And then it's not even clear when you go do these originalist analysis whether what they're even saying is right. Like, is it, if I say I'm an originalist and I look at history, is it going to give me a right answer, or is it just going to end up being the same thing that, that conservative justices are going to pick and choose the history that, helps them, and liberal justice is the other way. So this whole question of, this so-called legislating from the bench, which is a question that comes up a lot, and there are difficult issues there. But the idea that originalism somehow is a solution to that is also in question. Okay, so all that comes up in these cases. I'll just go kind of quickly the background here. So, well, first I just want to go back to this. There's a big question here about whether this is even an individual right at all. It's talking about the militia, right? It's talking about keeping and bear arms. It sounds military. It doesn't sound like having a handgun for self-defense. And that was the law. Just to back up, in 1939 we had the U.S. v. Miller case. There was a bank robber prosecuted for having a sawed-off shotgun and under federal law, and the Supreme Court said, does the federal law violate the Second Amendment? Does it violate the right to bear arms? And they say no, because it is limited to, the purpose of the Second Amendment is to protect state militias. It's not an individual right. And this decision was steeped in originalism, all about the original purpose, etc., of the Second Amendment. So what was the militia? Well, what the court has told us was, the language that we get is, it was, in every state, it was all the able-bodied males, which we could edit and say, well, all the able-bodied white males, of course, at the time. So that's who was considered part of the militia. And this was, when we had the Constitution originally, there was no standing army in the United States. So Congress could call up an army, but if we were attacked, and that was a big worry, we were a small country, who was going to defend us? And the idea was, okay, well, we need to have militias in every state that can be called up for self-defense. And so the Constitution gives Congress the power to call the militia. It also says the president is the commander-in-chief of the militias. And so we had laws like in New York, there was a law saying that every able-bodied male had to own a gun, right? You had to get a musket, you had to have a bayonet, you had to have 24 cartridges. Yes?
When did the United States first have an army? Because it says United States, when did the first one?
So when did we?
Yeah.
So actually, that's a good question. I'd have to look. I mean, when the standing army started. So that's today we have a permit. You know, the Constitution provided for armies, but the army would get called up,
So what did the United
Yeah.
States do?
I'm going to ask if we
Yeah.
just wait and allow the professor
Okay.
to continue his presentation. We're going to have a question and answer session afterwards. And if you have any questions, I think that there were some cards that were sent around. Please feel free to put them on so he can come
All
back.
right. Anyway, so the idea was that that we needed the militia in every state, and so it was important this right to bear arms. At least one interpretation meant that preserving those militias so they could do self-defense. But a well-regulated militia, right, not individual rights. So that's what Miller said. Look, the federal law here bans this short-barreled shotgun. There's no need to have that in order to preserve a well-regulated militia. So the Second Amendment is not implicated here. Another theme, right? This case, and we heard about the Chevron standard with the EPA. We heard of Roe v. Wade and Casey. And another theme is, what weight is owed to precedents, right, that have been in the books for a long time. And the idea is you're not supposed to just overrule a precedent because you disagree with it or think it was, even if you would have voted against Roe v. Wade at the time, for example. The idea which Casey emphasized is that there needs to be something extra, right? And Rebecca talked about, there needs to be something extra before you overrule a precedent. So what do we do about, and we see the Supreme Court these days overruling a lot of precedents. Anyway, the big case now before Bruen was 2008. This was the first time that the Supreme Court in history said that the Second Amendment actually is an individual right. And so Washington, D.C. had a ban on handguns. Scalia says, Scalia was the writer of that opinion, Justice Scalia says that Second Amendment is not just for the militia, it includes a personal right of self-defense. And the whole language about the militia that's in there, that's just explaining why the amendment was put in place, but it doesn't limit the meaning. Like when you look at the phrase right to bear arms, that's not limited by the militia. The militia language is just an explanation of why we put that in there, but it doesn't limit the right to bear arms to keep and bear arms is broader. And then you say, okay, well, I have a right to bear arms. Does that include handguns, right? I could say, I want a little personal nuclear weapon at home, right? Do I have a right to that? You say, well, it's not any arm, right? It can't be any arm whatsoever. But the court says modern weapons in common use, such as handguns. So maybe we could have banned handguns years ago when they weren't in common use, but too late now. We didn't do that. Now they're protected by the Constitution. Okay, so this whole thing, did Heller get it right? There's been so much discussion about this whole. Once we start relying on history, how good is the Supreme Court at doing history? And then we get, all these professional historians coming at us and saying, no, you totally. We did like a linguists did a search of every time the phrase like bear arms had ever been used like in history, and it was military. It wasn't personal. So, and you get historians saying, you totally misread it. Afterwards, and Justice Breyer also, Justice Stevens also in his dissent relies on original sources to say, no, it's the other way around. So there's a lot of debate about that. And then Justice Breyer arguing, well, even if there is an individual right to bear arms, and it includes handguns, no rights are absolute. You have to balance, they can be limited for public safety, etc. And we have to balance those interests. Okay, finally, this is McDonald v. Chicago. This is just an interesting thing, is the Bill of Rights on its own actually only applies against the federal government. So the Second Amendment only restricts the federal government. It has nothing to do with New York. But most of the Bill of Rights, since the Civil War, we have the 14th Amendment, which again has that language which was important in the abortion context. No state shall deprive any person of life, liberty, for property without due process of law. That's where that word liberty, that's where the right to abortion used to stand. And the court has said that most of the Bill of Rights, like the free speech, etc., they also apply against the states through the 14th Amendment. So in this case, the court said the Second Amendment right from Heller. Heller was DC, which was federal government. It also restrains Chicago, Illinois and the states because the 14th Amendment, it's actually the 14th Amendment that protects the right to bear arms when states are at issue. Okay. All right, so Heller, though, said some restrictions are allowed. It said we have possession of mentally ill people possessing firearms, sensitive places that can be banned, schools and government buildings, conditions on, like, background checks and stuff. What about, and Heller only dealt with handguns inside the home, a total ban on handguns. What about public carry of handguns? Could that be restricted? So after Heller, we have the individual right to possess weapons, that's what comes out of that case, but we still have this question of what kind of regulations, what kind of restrictions can we have? So this is where we get to the Bruen case, because now New York, so New York respects Heller, you can own a handgun in your home, but it's public carry that was at issue. And so Justice Thomas gives he now gives us a test. He says that anytime we want to regulate guns today, it has to be a regulation that is consistent with historical traditions. It's not enough that there's an important interest. In other words, if you have a gun regulation that serves a vital public safety interest, it doesn't matter how good that law is if you can't find some example in history of a similar gun law from the past. Right? That's the rule right now. You don't even consider the interests of the government. And you can say, well, what about I want to manufacture a gun at home with a 3D printer? What's the historical 19th century rule on that? And there is none. So that's some of the complications here. And it says it's not, so we have to look for analogies. Any gun law, any regulation today has to have an analogy to historical precedent. And well, what does that mean? He says it doesn't, but an analogy does not require a dead ringer, or it doesn't have to be a twin, right? It doesn't have to be the exact same one. It has to just be kind of similar enough. So how do we do that? And Justice Thomas gives us an example, says, well, historically they would ban guns in schools and government buildings. We could now have other sensitive places. So you say, we want to ban guns in bars. And then so the question would be, well, is that similar enough to a government building or a schoolhouse, or is it different? It's all now about, like, can you make a good enough analogy? But it's not limited, right? We can still have newer regulations. All right, so then there's this whole historical analysis in the case where Justice Thomas goes through history and says, there is no historical, there's a couple, there actually are some, not enough historical analogs for New York's requirement. And basically that states cannot just prevent all ordinary citizens who want a handgun for self-defense, they cannot be generally blocked from getting that. Okay, some concurring opinions quickly. Kavanaugh, this is the one to watch, because this was a 6-3 opinion, but you have Kavanaugh and Roberts in the concurrence. So if they had gone the other way, that would have been the majority. And they have a more limited take. So that's emphasizing this. They say the main issue with New York is that it is a may issue state where the person who's deciding whether you can get the license, deciding proper cause, has a lot of discretion, right? And they're saying so they really focus on it being too much discretion, but they're saying the 43 states that are shall issue, either they don't require a permit for a handgun at all, and some of them, but some of them do require a permit, and some of them even have onerous requirements for getting a permit, but it's more objective, like there's less discretion on the government, like the rules are clearer. And this opinion is saying that all of those shall issue states, those are still okay. And this is actually interesting because it's not like there's just may issue versus shall issue. There's like a whole bunch of differences among these different states and how they do it. And at least Cabinet Roberts seem to be saying, this is a very limited, we're really just focused on the may issue question in this case, and we're not trying to call into question other gun regulations. And so there can be a variety of regulations. Alito, he just focuses in his concurrence on attacking Justice Breyer. We'll get to that. And then Justice Barrett, she just talks about some interesting problems of originalist interpretation that were not resolved here. I'll skip that part for now. Okay, Justice Breyer's dissent. And this is 3 justices joining, Justice Breyer plus Kagan and Sotomayor. He starts off with this, 42,222 Americans were killed by firearms in 2020. That's the first sentence of the dissent. And then he has 3 big criticisms. One is there should have been a trial in this case to find out how exactly the New York proper cause requirement works in real life. That was never done. They just struck it down without having a full factual record. Number 2, there's just the problem with this whole historical, where you just focus on whether there's a historical analog. Other rights, as I said, are not absolute. We have to look at the government's interest. But to say we don't even consider the government's interest until we can find some example of a similar law from history, he has a problem with that. And then this is a very extensive part of his opinion, but talking about when we try and do the history, we're getting it wrong. And he has, so he's saying, even if we accept this test that Justice Thomas about having to find a historical analogy, the history is the other way, right? That basically there are so many gun regulations from history, and basically what Justice Thomas's opinion is doing is just finding a reason to say that none of those count, differentiating every single one. Some of them are. This is a much longer quote, which is pretty interesting to read, but I'll just read it here. If these examples, that he goes through of other gun regulations from the past, if they don't show a tradition, a history of regulation that supports the validity of New York's law, what could? For example, like in the West, in the American West, there were total bans on guns, and Justice Thomas's opinion just, in the 19th century, just discounts all of those by saying, the West is different, that was the Wild West, that's not relevant, and then there's some other states that have similar laws to New York's, and they say, no, well, that's
But
not
they're only outliers.
Yeah, they're outliers, there's not enough examples, and it doesn't look like they were enforced. Well, maybe they weren't enforced because maybe people were complying with the law, and maybe you don't know whether they were enforced because you would have to get a historian to go into the archives to, a lot of these papers from like the 19th century or from the Wild West. It's not on the computer where you can just look up, what happened. Okay, so what now? So then New York came back. So this was a very important test case. So New York, sorry, we out of time? Or?
No, I just want a card from the lady who's giving
Oh,
it.
okay.
Thank you.
So New York comes back and tries to, now has a new, amends the law to try and comply, right? So it says we're going to have, if you want a handgun, fine. We're going to be a shall issue state, but you need to come in and you need to. I'm sorry, this is why did that pop up? Any questions? Sorry, I can't see where the mouse is. There we go. I don't know why I did that. I'll just put this here. And now I'll get rid of it. Okay. All right. So, okay, we're going to have to take a 16-hour course. And you have to do that, I think, right, every 3 years when your permit expires. We're going to have a whole list of sensitive places. And there's a whole bunch of them. These are just some of them. But public transportation, Times Square, places where alcohol is served. Private property, if you want to go into a restaurant or, to my house or wherever, I don't have my apartment, then you can only do it if I the default is you can't. The private property owner has to say, we give affirmative permission for people to come in, right? So these are the new shall issue restrictions in New York. So anyway, what's happening after Bruen now is there's just a whole bunch of lawsuits now that are trying to, that are kind of giving life into efforts to fight gun regulations, and a lot of litigation about what's a historical analog and what isn't. This was just last week, a district judge applying the test in Bruen, gutted that New York law that we just talked about. So said, application, so these things are being struck, that you have to list your family members and covenants, provide your social media accounts, have an in-person meeting to get the license, all of that's gone. Sensitive locations, went through the list of sensitive locations and says, okay, security in places of worship, that has to be allowed because there's no historical law we found that said that you couldn't have a gun in church or whatever. Summer camps, no. I did when I went to summer camp, but we didn't have handguns. I don't remember that. There were guns in my summer camp, but so you can't ban guns in summer camp. Public transportation, no historical analog for that. So if you want to bring your handgun on the subway or the bus, no problem. Places where alcoholic beverages, that we looked through history, we couldn't find any analogs to that. Times Square, no analogs, and 10 other ones, no analogs. And then this thing about private property having to give express permission, that's gone, that's out too. The property owner can still say, no handguns in my establishment, but it's now the onus is on the private property owner to say that. It's not automatic. Now this is just a district court judge. This is just one example of some of the questions that are arising. This is getting appealed to the Second Circuit. I wouldn't be surprised if the Second Circuit reverses a lot of this. And then eventually the Supreme Court again. And so I think just to kind of sum up, what are the sort of two big things? First of all, unquestionably, this is creating a lot of litigation and putting a lot of wind in the sails of people who want to fight gun regulations. On the other hand, as I mentioned, a lot now is depending on that Kavanaugh and Justice Roberts, who don't seem to be fully, even though they joined Justice Thomas's opinion, don't seem to be fully on board, and indicated that they were kind of open to having a variety of gun regulations. So that's going to be the question when these types of cases go back to the court. How are Kavanaugh and Roberts going to be looking at that? So those are all my, that's what I have to say about the case. And again, thanks so much.
Thank you very much, Professor Greenwald. I just have to mention that each of our panelists could have presented from the time we began. So they've curtailed what they have to share with us in the interest of time, but we could spend an entire day for each of them. And I think that kind of shows how important it is that we're informed, whichever way we choose to move forward if you vote, that you have an understanding at least of the issues and how complicated lots of these issues are. I'm going to suggest, well first before I do that, I want to just acknowledge that Mary Jane Shimsky is here now, and she's a member of the New York State Assembly. So please welcome her. No, yes, excuse me, yes.
County legislator.
County legislator, potential member of the New York State Assembly. Yes, but the election still has to occur. And I'm going to suggest that we have a 5-minute break before we come back for questions. If anybody has already filled out a card, that's wonderful. If not, then we'll entertain your questions anyway.
Thank everybody for thinking intelligently about the presentations just made and then framing very intelligent and probing questions for the panelists. We'll see if we can stump them. Maybe we can. The first one I have is directed to Professor Caldwell, and that refers to you described the Chevron principle of deference to administrative agencies. That is, if there was nothing specific in the law, the trend was to defer to the agency's expertise in stating whatever it stated as a rule or regulation. And in the EPA case, you said that rule for deference was pretty well tossed out. It was remedied by the Congress going back in almost immediately and clarifying the law that was not specific enough. But do you feel that this will stand as precedent for all administrative law, that all enabling acts for administrative agencies will have to be reworked by Congress, or they're going to stand in jeopardy of being tossed?
There definitely is a trend on this court away from deference to agencies, and by looking to the major questions doctrine in this case, the court said that, hey, this issue is too important here, so this is something that needs to be decided by the legislature, so we're not going to defer to the agency in this case. That the major questions doctrine has only been applied in a few Supreme Court cases up until now, and was only coined the major questions doctrine in this particular decision. So it will be interesting to see, how often it is applied going forward. I think that, climate change is a particularly, it's a very political topic, and one that you can see why the court got to saying that, hey, this is a big issue that needs to be decided by the legislature, even though there's nothing in the Clean Air Act. The Clean Air Act gives EPA the authority to regulate air pollutants, and there's nothing in the Clean Air Act that says that air pollutants can't include greenhouse gases. So I guess the answer is, I think, yes, there is a trend away from deference to agencies right now, but I think that this type of circumstance where the court will go to the major questions doctrine is probably limited.
Well, Professor, do you foresee a circumstance where, let's say, similar analysis applies to, let's say, the FDA or to the SEC or the IRS?
Yes, yes. First, so I do think that this will come up again with the SEC rule. It actually started, this major question doctrine did start with the FDA. It started with a case where the FDA said that they had authority to regulate tobacco products, and the Supreme Court, because they have the authority to regulate drugs, and the Supreme Court held that actually no, that wasn't what the authority that Congress granted them, that this fell under that major questions doctrine.
Thank you very much. We have a question for Professor Greenawalt, and it is it plausible to establish a compelling state interest, assuming that's the test, for enhanced liability laws on insurance requirements for gun ownership or training requirements?
Okay, so that's a great question, and so there's two parts of it. So one is that this idea of compelling interest. So when we think about constitutional rights, the way it has sort of normally worked, like right of parents have a fundamental right to direct the upbringing of their children. That's also not in the Constitution. We have a right not to be forcibly sterilized by the state. That's also not in the Constitution. Actually, compulsory right to not have compulsory abortion, also not in the Constitution, right? But these fundamental rights that have been identified, the court says they go through strict scrutiny. So if you're going to infringe upon the right, then it can be limited. So the government, so direct the upbringing of your children. Just giving you an example from other rights, just to get the concept. I'm a parent. That does not mean that child abuse is okay, right? It's not I'm not the owner of my children. So the government has a compelling interest in protecting children from abusive parents, and they can pass laws that advance that interest and are narrowly tailored, kind of necessary to promote that interest. So the idea is when you have a fundamental right, a narrowly tailored, compelling interest can override that. And then, and then we have that's the strict scrutiny. There's for sex discrimination, there's intermediate scrutiny, which is that, not quite as strict. We're going to allow separate bathrooms and things like that, but there's still going to be a lot of scrutiny over sex discrimination. So what's interesting about the Second Amendment is the court is saying that is not the analysis here. They didn't even ask in the Bruen case whether New York's regulations on handguns was necessary to advance a compelling government interest. The court said that that's what I meant, but you don't even look at that. If there's no historical analog for it, the government interest doesn't matter. So that's kind of one thing. So this question about this is another one of these questions now about what does have historical analog. So I think that insurance, do you have to get insurance with your gun like car insurance? And there is a historical analog. There are these surety laws where, and it's sort of a little, you see it's discussed in the Bruen opinion, a little unclear debate about how broad these were, but there were laws that said if you wanted to carry your gun out in public, you had to first pay a deposit, a lot of money, to cover any damage that you did. And that was one type of gun restriction. And so one argument is, well, this is that's a historical example, and insurance today, it's kind of similar enough to that, so maybe that works. Or maybe you say, no, it doesn't work, it's too different, right? But it's not treating, the Bruen opinion, is there a compelling government interest? Is public safety? It's not even, that's not part of the analysis.
Professor, if you were to have an insurance requirement, would that have other constitutional implications? For instance, would that potentially discriminate against poor people who might not be able to afford a premium?
Well, I guess, yeah. So one thing, when we talk about equal protection, so that's that's the equal protection argument. So there's also an equal protection guarantee. There wasn't originally they were not interested in equal protection for obvious reasons. After the Civil War, only after the Civil War did we get equal protection as part of the Constitution. One thing I talk about when I teach the class is every law is unequal in some sense. We read a case where the opticians are being treated unequally to the opticians are being treated unequally to the ophthalmologists, right? Or my kids can't drive until they get to a certain age. That's age discrimination, right? So so the way the court does it, they say only certain types of discrimination get the higher scrutiny. So racial discrimination, number one. That's the clearest one. Sex discrimination as well. But poverty, that's not. That doesn't get that. So the fact that it would be more expensive, I think there's a lot of room to interpret the Constitution in ways that would, maybe there should be more protection on those grounds. But according to the current doctrine, laws that advantage wealthy people over less wealthy people don't get that higher scrutiny. So that I don't think, maybe there's other arguments, but I don't think, my gut reaction is I don't think that would be an issue.
Thank you, Professor. Yeah. We have a question also for Rebecca Angel. Ms. Angel, in states that ban or restrict abortions, if women want to end their pregnancy, will they be able to receive the abortion pill? And to what extent do you think such rights such as gay marriage, etc., are also at risk as a result of the recent decisions?
So the abortion pill right now is FDA regulated. So that means the FDA, it's a complicated state versus federal because right now the FDA approves it and everything, so people could get it. But as we see these laws like take place, there might be issues with that. I don't know if you have any thoughts, Professor Greenwald, on that.
Well, I mean, so there's one, so I think there's sort of one issue is like people traveling, like if you live in Texas, traveling to another state to either do a medication abortion or get have a procedure. And I think the Kavanaugh opinion, at least in Dobbs, is saying that, you know, if Texas tries to criminalize that, we're going to have a problem with that because there's a right to travel.
Right.
The trickier situation is, what if you have a doctor in Massachusetts who does like a telehealth appointment with a patient in Texas and then mails the abortion pills to Texas? And right now there's also website 8 Access that you can go to where it's you do a telehealth visit, I think in the Netherlands, and then the prescription gets sent to India and gets mailed. And that's, so now that, I think this is one reason why we're in a different world than we were before, because so many abortions either are a pill or could be a pill, right? You know, people who are pregnant often choose the procedure because they prefer it, but they could do the pill. And so it's very hard to prevent the pills from coming in the mail. So Massachusetts actually just passed a law saying that protecting its doctors, saying that you cannot, they will not cooperate with any like investigation from Texas that tries to prosecute a Massachusetts doctor, including for a telehealth visit, right, where the patient was in Texas. And also says, if you sue the doctor, if Texas creates, I'm not picking on Texas, giving one example. If Texas were to create a civil law saying that that Texas will sue a doctor in Massachusetts for doing that, Massachusetts has now created a counter lawsuit where they can, now in Massachusetts you can sue back for interfering with Massachusetts healthcare, so the two lawsuits would cancel each other. So these are some of the issues that, you know, the whole point was that, like, in the Supreme Court, and, you know, Dobbs was saying, you know, the Casey and abortion rights, it was so divisive and so many questions and unmanageable, and now we're resolving it. It's not resolved. There's like a gazillion other questions that now have to come up to the courts. Yeah. So.
And then the other part about if other cases are at risk.
Yes.
So Alito, who wrote the opinion, multiple times says that this decision is different because it involves potential life, or however they framed it in the Mississippi law. So he said those other cases aren't at risk, but what's hard to believe about that is his whole reasoning is basically this isn't deeply rooted in history and tradition, but he's looking at the criminalization as the reason that's not deeply rooted, because there have been abortions like forever. It's just whether they've been legal or not. So when we look at other rights, I don't think, you know, Loving versus Virginia, the interracial marriage case is at risk, but, you know, I can't say 100%. They said these aren't at risk, but if you do look at the history and tradition, you'll see obviously they were criminalized. So the reasoning doesn't line up with his conclusion, and that's what kind of the dissent was pointing at. So there are a lot of other unenumerated rights, and something that Justice Thomas was saying is that all those cases, basically, that aren't written in the Constitution under substantive due process should be reconsidered and overturned. And he's not the majority, like, necessarily, but, you know, that's kind of the argument. Yeah.
And Justice Thomas is actually in an interracial marriage, is that
Yeah,
correct?
but he didn't quote that. Interestingly, he didn't quote Loving versus Virginia, but he quoted Obergefell, which was the gay marriage case. But they were held on the same grounds, equal protection and due process.
Yeah. That's what I was just going to say, is that you could get rid of all the due process cases, and maybe we'd be back to, you know, Buck v. Bell, the case where there was compulsory sterilization of teenagers, etc. Right? I mean, but they could do all that. But then Loving versus Virginia still had a separate argument, which is equal protection. So I think that's the most secure of all of them. Yeah.
As well as Obergefell, hopefully, because that's also an equal protection case. But you know, we'll see.
Well, here's a question for the panel. Do you believe that the Supreme Court should have term limits? Should there be an increased number of justices as well?
Can I say one thing? Something I didn't realize is that in the Constitution it says the justices should be there on good behavior, which has been implied or serve on good behavior has been implied to be life terms. But it's not actually written that it's life term, it's implied. So I don't know if there's a challenge with that. But maybe.
Well, now you have me looking up. Article 3. When my brother was in law school, the students went around with a video camera and popped into professors' offices and asked, like a quiz, how many amendments are there to the Constitution? Half the professors had no idea. But so the Constitution has life tenure for, right, so it says, right, so hold their offices during good behavior. The understanding is it's life tenure. But I think this is so the argument for term limits would be, yeah, you have life tenure as a federal judge, but we can rotate you on and off the Supreme Court, and so that we could just have, the Supreme Court could have term limits, but you could be rotated back to another federal judgeship. So I think that's one argument. I think that would be good. Then the other one is, and I think what would be good about that is that what happens is the stakes lower a little bit because individual justices become less important. They're going to rotate on and off. So maybe the appointments battles will be less divisive. But also one of the arguments is that it will lead towards more of an institution and less the sort of personal power of the judges, because every judge knows they're only there for a limited time anyway, and so maybe we'll have less of these extreme, overrulings happening. That's kind of one idea. The other one, increasing the size, there's nothing in the Constitution that says it has to be 9 justices. It has been different numbers in history. I think that there's a lot of arguments, especially people saying, well, one argument is, the Senate stole an appointment from Obama when Merrick Garland, and then because it was an election year, and then of course Justice Ginsburg replaced much closer to the election, and so forth, that it would be appropriate to expand the size of the court. And so there's these arguments about that too, but that sort of court packing idea, it also came up with FDR during the New Deal, which was the last time when you had a court that was very actively striking down kind of democratic majorities in the country. I think that the question is, it is a bit of a nuclear option to do that, because the concern is then we just even more just see the Supreme Court's just another political actor, just pack it with your justices to get your results. But there's another argument is that we're already there, right? So I think that's kind of where we are already. Yeah.
Even though he didn't actually do it, it worked.
What'd you say?
It worked for Roosevelt.
Yeah, the switch in time that saved 9. There was Justice Roberts, the earlier Justice Roberts, who. So back then they were saying the court was saying there was a fundamental right to freedom of contract, which meant that if we wanted to say, child labor laws or minimum wage, or you can only work in a factory, so many hours a week. No, employers and employees have freedom of contract to decide whatever they want. And that was during the Great Depression, when there was massive public support for greater intervention in the economy. The Supreme Court was standing in the way. And eventually, the court packing plan, and FDR could have done it. He had veto-proof majorities in Congress. But Justice Roberts switched his vote, and it started voting the other way, and it became unnecessary. Which actually is another interesting question we're looking at today, which is, how far can the Supreme Court drift from popular opinion in this country, without there being a correction, like one way or another, right? And so people who are interested in that question, it's an interesting time for them, because that's starting, that may be the path that we're heading down now, and so that'll be interesting to watch as well.
Professor Caldwell, do you have, what are your thoughts with respect to this question?
I don't have anything to add. I agree that the court packing idea, that then we just end up with an even more politicized court. But to Professor Grunwald's point that we may already were already there too.
Let me ask you, just with respect to judicial economy, the court hears a limited number of cases. Do you think that it might be beneficial if there were more justices and in terms of allowing them to hear more cases?
Oh, with more, yeah. I mean, it's an issue. I don't have. I mean, it is the case the Supreme Court used to hear more cases than it does now. It's also the case, even when I was researching this for today, when you research an older case like Miller, it's like 10 pages long, and you look up Brune, it's like 150 pages,
and Dobbs is over 200.
Yeah, so so that would be a potential advantage. Would be so if they had a larger Supreme Court and then split themselves into panels like the Court of Appeals do, then they could hear more cases. And I guess part of that depends on, back to the political question, do you want the current Supreme Court to hear more cases or fewer cases? And that could depend on whether you like what the Supreme Court is doing these days or not. So,
well, there's also their motion practice has exploded.
Oh, the shadow docket.
Right.
They've
So
been issuing more.
only having 9 people handle a much larger amount, I mean, that really adds to the workload, and is it too much?
I just would like to revisit, well, if you have an answer to that question, please, if anyone does, or a suggestion, any comments. If not, I just wanted to go back to what Ms. Angel said before, talking about good behavior. And does anyone on the panel consider that good behavior may also include general competence? So for instance, if you lack competency, and not in a political sense, but let's assume that a person begins to lose their faculties, should we simply cycle that person off of the Supreme Court into another federal position, federal bench, or should that person at that point be found no longer capable of fulfilling the office's requirements?
I think there was only one time that a Supreme Court justice was impeached, and the impeachment process, just like with the president, is how you would remove a Supreme Court justice. But like, if they were all of a sudden just going rogue and I don't know, like mentally just not competent, then I think there'd be good claim to impeach the Supreme Court justice, maybe.
Well, I've had the pleasure of appearing and observing someone argue before the Supreme Court, and the justices turned their backs to the people who were presenting arguments. They rocked back and forth in their chairs, and it seemed very unbecoming of any court to me. I've been in village courts and town courts. No justice or judge ever conducted themselves that way. So when we talk about good behavior, I was looking for it that day. And my colleague won their argument, but it didn't leave me with a very good feeling. So is that something that ought to be considered? Because we ask for the public to have great deference and great respect for the court, and should that also be reciprocated?
Sorry.
And good behavior, does it mean conflict of interest?
I don't know how much good behavior has been like defined, because it was only one justice that had ever been impeached. Do you know?
Well, I would just say, I mean, it could be, the thing with all of this is, so yeah, conflict of interest, and that's come up a lot. It's come up before, you know, when Justice Scalia and Dick Cheney were going hunting trips together, and it came up now with Justice Thomas and his wife. But so practically speaking, who decides what's the part of our government that decides when a justice should recuse? It's the Supreme Court. So they're deciding for themselves, right? So that's practically, it's what they say it is. And then for impeachment, yes, that's the way that that's how a Supreme Court justice can get fired, is through impeachment. And we just went through impeachment twice with the president, and so as we saw, you know, January 6th did not, neither succeeded, because you need majority in the House and 2/3 right in the Senate to convict. So so it ends up being, I think, less about whatever the standard is than just that those are the hurdles you have to go through to do those things. But the idea that you raised about what if there was, if we are rotating justices on and off the Supreme Court, what about then if they said, well, this justice seems to be, in declining health or something, and we're gonna, these are untested constitutional law questions, so I don't know the answer. Yeah.
But I do know Thomas did recuse himself for one case. It was the Virginia military.
Oh, VMI?
Yeah.
Oh, yeah.
Because his son attended this school. That was an issue. So he recused himself. He didn't take part in the decision. So that can happen at times too.
We have a few more questions. We're coming toward the end time-wise, so if we can agree to spend maybe 30 seconds apiece so we can get through the rest of the questions. And one of them is, what is the process for challenging a Supreme Court decision, and how can the court make such sweeping decisions without considering implications? If you could each take those 30 seconds to answer that softball.
I mean, the ultimate answer is that if the legislature can, speak clearly to these issues that at the federal level, because there's the different branches of government, right? And they're all supposed to balance each other out. But I think, that's its own issue is having the federal legislature agreeing and addressing some of these key issues. And then there's still the interpretation of the statutes and all of that, but that's one way. The other way is that now that the Supreme Court seems more likely to reverse itself than in the past, continuing to have these cases work their way up through the federal court system, and get back before the Supreme Court. That's another way, but there's not an easy answer.
I have another question, and that was, is the New York statute in response to the Supreme Court decision more restrictive than the previous statute?
The gun?
Yes.
Yeah, I mean, I think it's less restrictive in some ways because it does increase access to handguns. It's still very restrictive. This reminds me, I forgot to mention in my presentation, but the New York handgun laws existed for over 100 years. And so when they did the history and tradition analysis, they didn't include that as part of the history. And then but they have said repeatedly that preventing felons from having handguns, that's okay. But guess what? When you look at history, the laws prohibiting felons are newer than the New York law that got struck down. That was a 20th century thing. So anyway, that just reminded me about that. I'm sorry, and so yeah, I don't think it's, I mean, I guess it depends. It is quite restrictive, the new New York law, but I think it's still less restrictive. Well, I guess it's, yeah, people, I would say overall, you could see it either way, but I would say it's less restrictive.
And the last one that I'm going to read, I have one more, but it's very long, so I don't know that we'll get through it, but there's one more. Is there a code of conduct for the Supreme Court of the United States? And if so, how is it established? How was it established?
So this, I don't think any of us, I'm not an expert on this question, but so in terms of, but I mean, there are people who work on, who are ethics people will 100% know the answer to this question.
I don't believe that there is.
My answer is good. That's what I was going to say. And they regulate themselves. Yeah. So, and even if there was a code of conduct, they would still be the ones. It would be their code of conduct that they wrote and that they were enforcing. There's no outside. Yeah.
But there is for every attorney that appears before them and for all lower judges.
Isn't that true? Isn't that the same with Congress? I mean, where's the code of conduct there?
That's a very interesting
So-
question.
I'll tell you where the code of conduct is voters.
I want them to be held to a certain standard.
Well, Congress recently passed internal regulations, that precluded them from engaging in insider trading, a host of
They didn't pass that law.
well, no, it's not a law. It was not a law, but it was their code of conduct.
Never brought it out of Congress.
This goes back years ago,
And
and they are
obviously
not.
living by it, are they?
No, they're not, but it exists. So they're not living by it, but again, if anybody here engaged in the same conduct, then you could be charged criminally. So that's a very good point. Yeah. And self-dealing, other self-dealing rules. I think that we have reached the conclusion of our panel discussion today, but I would first of all just absolutely thank our panelists. I think they've been tremendous. I thank you for tailoring it. Again, I know that each of them could have gone far beyond what we were able to do today. I thank all of you for your attentiveness and of course the League of Women Voters and co-sponsors for allowing us to have this forum today. So hopefully we will have other events in the near future. Thank you very much again. I thank you for inviting me to participate today.
And I want to add our thanks to Attorney Bartlett for being a wonderful moderator. Thank you so much for the work you did this morning. So again, please look on our website for future events. There will be 3 candidate forums next week. So please check the website and pick up any pamphlets that you like on our table. Thank you again all for coming.